and welcome to the show. Today's guest is Roberto Guzman, legal assistant with 20 years experience in the area of criminal appeals and civil rights. To talk with us today to explain what the Miranda warnings are and the ramifications of waiving the rights to remain silent and how doing so can affect you at trial. Hi, Roberto.
Hello. Thank you for having me. Good morning.
Tell us a little bit about yourself and how you became
Interested in the law?
Yes, interested in law.
I'm a paralegal with 20 years experience, as you said, in the area of criminal appeals and civil rights. I do basic legal research and some brief writing. What interests me most about my job is helping others vindicate their rights, primarily through the appeals process. I don't do much trial work. And in the mix of all that, I've come to have a grasp for the law, and I see how real life situations play out in the courtroom. So anyway, I'm a paralegal, like with 20 years experience. We started an organization in 2009 called the People's Task Force to investigate crime labs. And we took this bull by the horns, if you will, in Detroit over the scandals involving the Detroit crime lab, where I don't know if you were aware of what was going on at the time, where the Michigan State Police had investigated a certain percentage of these cases involving ballistics evidence, and they found an error rate that was alarmingly high, where the ballistics evidence was bungled or mishandled by Detroit police, and people were convicted on this.
I remember that.
So that's where my organization started in 2009, and since then I've sort of expanded, if you will, my practice to include the meat and potatoes of people's rights that are violated in the terms of illegal confessions, cases involving the crime lab, and just everything at this point that I'm handling on appeals.
Okay, great. Explain to our audience, please, what actually is Miranda Rights? What is the Miranda Right?
Your Miranda rights, as we know from pop culture and on television, is your right to remain silent, and that anything you say in that interrogation room when you are arrested can and will be used against you in a court of law. And they are as follows.
Now, can you say that one more time? Can and will
be used against you in a court of law. And it doesn't only include confessions. It can include so much of a statement that you give that you may think you're helping yourself and you didn't confess, and you're at trial, and guess what? You said just enough that will convict you, in addition to all the other evidence. So this is why, hopefully, when we leave here today, I have impressed upon people the importance of the right to remain silent. Assert your right to remain silent. Just say, don't tell the police anything without a lawyer present in that interrogation room.
Okay, so what should they say? I'm the police officer. Let's pretend I'm the police officer and I'm questioning you and I'm saying where were you at 9 o'clock? Were you on Greenwood Street in Detroit, Michigan? Were you there while that young man was being robbed and killed?
At that point, you assert your right to remain silent. Affirmatively so. You're being interrogated as a suspect. And the key in American court, in American law, is that there's two important elements to determine when the police have to read you your Miranda rights. When you're in custody and when you're being interrogated. There's no question, when you're taken down to the police headquarters, you're in custody. So at the example you just gave, that's when you better assert your right to remain silent. Don't admit and don't deny that you were at that crime scene, because you can say, like I said earlier, just enough, short of a confession, that will nail you at trial. What you should say at that point is, officer, I have nothing to say to you until I speak with an attorney. That's it. It's easy, it's simple.
Okay, and once the person says that, then that is just the end.
It's supposed to be the end. And yes, the officer is supposed to cease interrogating you. He has to stop questioning you until you can get a lawyer, and if you can't afford one
will be appointed.
One to be appointed for you, which is what Miranda says. Okay. But yes, legally speaking, the officer has to stop interrogating you.
Okay, and at this time then, So what they should know is that yes, you are going off to jail because you are in custody, but you will get a lawyer and you will get a chance to tell your side of the story, but to the lawyer,
Yes.
someone that's going to defend you.
Yes.
Okay, great.
What happens in the interrogation room, I like that example you gave. If the police, I think what they're supposed to do at that point, they're supposed to get you a lawyer right at that point, even if you can't afford, even if you can, in other words, the police don't have to wait until you're arraigned on the charges before you get a lawyer. The police have an obligation to go get a lawyer and bring that lawyer in that interrogation room. They don't tell people this.
Okay.
They're supposed to do that. Once you assert your right to remain silent, the state courts have what they call a pool of lawyers whose jobs are to handle Miranda interrogations. They go to the police stations. They're not your lawyer, but they're court appointed. And the police are supposed to go get a lawyer once you assert their right to remain silent. They're supposed to go get a lawyer or wait till, contact the court or and have a lawyer brought to the police station.
Okay, I'm glad you said that because is there a time limit? Is it a 72-hour, 48-hour, 3 days, a week? I mean, because you have a right to a speedy trial, right? Well, so if that's the case, then you need a lawyer like quickly, like right away. You shouldn't be sitting in jail for 2 months, and then so how long should it be before you are appointed? If you need to be appointed a lawyer, if you can't afford one, a court appointed a lawyer.
Okay, police can legally hold you for 72 hours while they're investigating the crime. They can't give you 72 hours to decide whether you want to assert your Miranda rights or not. But at the moment you assert your right to remain silent until a lawyer is present, they have to go get a lawyer for you. And the police don't tell everybody this. But there are lawyers who do go to the police station, as I said a moment ago, that come into the interrogation room and they defend your rights while the police officer is interrogating you. So they have to, as quickly as possible, get you a lawyer once you assert your right to remain silent in that interrogation room. Okay. And if they don't do that, they cannot resume interrogating you because you've asserted your Miranda right. The 72-hour window that you're talking about is different. That's that's to give the police time to investigate you and possibly charge you for a crime. But they cannot detain you past 72 hours if you have not been charged. Okay. So that 72-hour window that you're talking about is not to see whether you're going to waive or assert your Miranda rights. That's to give them time to investigate the crime, to continue holding you past that 72 hours, and then take you in front of a magistrate, have you arraigned, et cetera, et cetera.
Okay. But the most important thing is that what you're trying to stress is that when you get into the interrogation room, say nothing. Just keep saying that I want a lawyer. No matter what the police officer or the detective is saying to you. Sometimes there's one, sometimes there's two. So it doesn't matter. Even if they team up on you, just keep saying, I want a lawyer. Yes. I want a lawyer.
Yes.
Okay, great. I get that.
Yes.
Can police question a person without reading them their Miranda rights? And when should Miranda rights actually be read? At what point should they be read at? When the police pull you over, at the crime scene, whatever, whenever you're presented, when should they be read? At what point?
Okay, that's a good question. The roadside stop is what I think you have in mind. And
yes.
Generally, roadside detentions are not subject to Miranda warnings. However, if the officer begins interrogating you at the traffic stop about a crime, you are arguably in custody. Okay. Again, the key thing to remember is whether you are in custody, that triggers Miranda warnings. And custody legally means is anytime the police deprive you of your freedom of action in any significant way. Now, one can make the argument, well, you're pulling me over for a broken tail light.
Yes.
And so you should be reading me my Miranda rights. No, not necessarily. Roadside detentions are a lot different than custodial interrogations in the police station. No question about the latter, you're in custody. However, when the police pull you over for, say, a traffic light or a traffic violation, they do not have, and say, for instance, okay, I'll give you an example. That's a misdemeanor. They don't have to Mirandize you for misdemeanors. They have the evidence. Your traffic light is broken. They're going to read you. They're not going to read you. They're going to write you a traffic ticket.
So felonies only?
Only for felonies.
Okay.
Only for felonies.
Only for felonies.
Police do not have to Mirandize you for misdemeanors or traffic violations. That makes sense. They write you a ticket, right? Okay. But let's say, for instance, they pull you over.
Did you guys get that? Miranda rights are read to you only for felonies.
Only for felonies.
Okay.
If you, you know, you don't have to be Mirandized, for instance, for domestic violence. That's a misdemeanor. But I'm just throwing something out there. Or for disorderly conduct. Okay. Generally, the police see you committing disorderly conduct, they arrest you. There's no, they don't need to Mirandize you. You're being arrested. Those are misdemeanors. That's what I'm saying. But going back to the traffic stop, the roadside detention, those are very interesting cases because, again, are you in custody? One can argue, a good lawyer will say, well, yeah, you were in custody. Your freedom of movement was restricted. So therefore, the police, even though you're not in handcuffs, you're sitting in the driver's seat, you're in custody. At that point, you are in custody. Your freedom of movement is, again, the definition is your freedom of action is restricted in any significant way. You know you can't drive away when you're pulled over. But let's say while they're writing you the ticket, the officer sees a gun on the console.
Wow. Okay.
Now, that's a felony. So it goes from stopping you for the traffic violation to,
if
somebody's...
you don't have a gun permit, that's a felony. If you have a gun permit, though, it's not a felony.
No, it isn't. But the officer sees enough that at that point he has what? Probable cause. He can start asking you about that gun. And when he starts asking you about that gun, what's happening now? Miranda kicks in, doesn't it? Your Miranda rights kick in.
Yes, exactly.
Say you're not the only one in the car. Say, and generally, you're the driver, there's a passenger, and the gun is on the console. So the question in the officer's mind is, whose gun is this? Now, it went from pulling you over for that traffic stop to questioning who he's going to question. More likely the driver.
And that's a felony. Without a gun permit.
But the officer doesn't know if you have a, wait a minute, but the officer doesn't know whether you have a permit or not. He has probable cause now to arrest probably everybody in that vehicle because somebody has a gun. Now, if somebody can produce a permit, he'll let you go, won't he?
Yes.
Hopefully. He's going to ask, because if you have a permit to carry a gun, you're supposed to carry the permit on you too, aren't you?
Yes.
Okay, so that's easy. But let's say nobody has a permit and somebody is in possession of that gun illegally in that car. I'm talking about someone who does not have a permit. Okay. Somebody's going to jail, aren't they? From that traffic stop.
Yes.
This happens a lot in traffic stops.
Now that has turned into a felony.
It's turned into a felony.
Because it's a gun involved and no one has a gun permit.
And there you go. So now what kicks in? Custody. Custody kicks in. And the officer starts interrogating you. You're the driver. Now, at that point, he's asking you, whose gun is that on the console? He hasn't Mirandized you. Say and you confess, yeah, that's my gun. Was that an illegal confession? Think about it. But he didn't Mirandize you. I think a good lawyer in court could challenge that and throw your confession out if you admit that gun was yours. Because even though it's a roadside detention, he started questioning you about felony possession of a gun. Interesting, the concept of possession for purposes of the law is there's two types of possession. Personal possession, the gun is on you, and then there is what is called constructive possession. The gun is within your control. It's on that console. You're in possession of that gun
because it's in your vehicle.
It's in
and
your
you're the
area
driver.
of control. Yes.
Okay.
So that's the perfect example of a roadside stop where Miranda does kick in because the officer saw evidence of a crime.
Okay, so let's go to that. Now everyone's going down. Police are checking everyone in the vehicle. Everyone's going down, right?
Yes.
So now this
because they want to know whose gun.
Because they want to know whose gun is this, and so now this is leading into something what you call co-defendants.
Yes.
Is that correct?
Yes.
Okay, and so now they have separated.
At the police station.
At the police station. They've separated all parties that were in the car, right? And they're questioning all parties that were in the car.
Trying to find out whose gun this belongs to.
Trying to find out who guns this belongs to.
And let's say no one had a permit to carry that weapon.
Okay. And let's say that they're telling you, saying to you, well, your buddy is in the other room and he's ratting you out. He's telling everything that happened.
That this gun was yours?
Yes. Now, at that point, what should you do?
that comes up a lot in co-defendant situations. And yes, police will separate the defendants in different interrogation rooms. One officer is in the one room and another officer is in the room with you. And they, yeah, your buddies in the next room are ratting you out, so why don't you just tell us what we want to know, and you know, we'll let you go, or you'll make things easier on you if you just tell us what we want to know. And your buddy, like, again, is in the room ratting you out. Well, I always think, I think my take on that is this. You can turn around and ask the officer questions. You don't have to answer his questions. First of all, did he Mirandize you? Because he's asking you to admit to criminal possession of this gun. Nobody has a permit to carry the gun. It was on the console of the car. So the question now is, was it your gun as the driver or your friend's as the passenger? So when he tells you your buddy's in the next room ratting you out, say, well, that's interesting. What did my buddy say? Turn the interrogation around. But don't confess. If you put the gun on the console and you confess, you're going to be charged with criminal possession of the firearm.
Okay.
And so, well, tell me exactly what my buddy said, or bring my buddy in this room and let me hear him confess. Let me hear him put the gun on me. The officer will shut down. More than likely, he'll shut down because he knows that you know what he's getting at. And keep in mind, your buddy
they have no intentions on putting you two together.
But there's nothing wrong with them putting you together in the same room. If you're telling me my buddy is ratting me out, bring him in this interrogation room and let him rat me out in my presence. Because I'm not going to confess to that gun. It's not, I'm not going to confess to it. It's not my, I want a lawyer present. I have nothing to say to you. Go get me a lawyer. That's how you handle that. I'm not going to confess to anything. I want a lawyer present. And if my buddy is ratting me out, bring him in this room with me and let me hear him rat me out. Or what did my buddy tell you? Tell me what he said. If that officer can't tell you what your buddy said, your buddy probably didn't rat you out. So these are tricks that the officer uses to get you to do what? To confess. Yeah, man, it's mine. I put it on the console when I saw you pulling me over. Which is silly. Most people would try to throw it out the window, but you get the gist of what I'm saying.
Yes.
So
exactly.
They're trying to break your will to confess to possession of that firearm. And in that instance, if you do confess, that's not an illegal confession, provided the officer read you your Miranda rights. You know, you have the right to remain silent. Anything you say can and will be used against you. If he reads you your Miranda rights, and later on he's telling you your buddy's ratting you out, he read you your Miranda rights. You can't later in court say, well, that was an involuntary confession because he lied and told me my buddy ratted me out. There's nothing illegal about the officer lying.
Okay.
What's illegal is did he coerce your confession? Did he beat you?
Yes.
Did he press? Not just beating you. Did he pressure you? Did he break your free will to assert your Miranda rights? No, he lied. He lied about your buddy ratting you out, but he didn't put a hand on you. He didn't say you better tell me what I want to know right now, or you're never going to get any sleep. We're going to hold you in here forever in this interrogation room.
Right.
He did not break your free will, and you confessed. It's going to be used against you.
Okay, now let me ask you this. Can a police officer that's interrogating you or detective promise you leniency?
That's a good question because that comes up all the time where the officer is interrogating you and he's telling you, look, if you just tell us what we want to know, we'll make this easy on you. Look, we just called the prosecutor's office. You're being interrogated at 11 o'clock at night or even 11 o'clock in the morning. They use this trick and it works all the time. Here's how they do it. If you just tell us what we want to know, you know you're looking at life in prison. But if you tell us what we want to know, we'll strike a plea deal with you. We already got the prosecutor to okay this. And the prosecutor said you'll only get 10 years to maybe 30 years, 10 to 30 years in prison. And then you spill your guts out. You let it all out. You confessed. He Mirandized you. Let me go back. He Mirandized you. He read you your rights to remain silent. And then he promised you leniency and says he talked to Kim Worthy downtown and her office gave him the approval to strike this plea deal with you.
And Kim Worthy is the prosecutor for Wayne County.
Wayne County. And he got her permission to strike a plea deal with you in that interrogation room. Your question is, can they make promises of leniency and will it hold up in court? No, it will not. And you confessed.
No, it will not.
And is that confession illegal under that circumstance? I think, no, it's not illegal.
Okay. But you went for it because you didn't know.
You didn't know. But so this is why I'm here today to tell you that is not you can't bind the prosecutor to a police officer's promise of leniency. It's if you go in, when you're charged and you're in court, and you're saying, but wait a minute, the officer promised I would only get 10 years. The prosecutor's going to stand up there and say, we didn't promise you anything. And this happens a lot. People, you need to be aware. A police officer cannot make a plea deal in the interrogation room. It's an old trick. It works. And what I mean when I say it works, if you confess in response to that officer's promise of leniency, and later in court you try to get that confession thrown out, good luck.
Okay.
Because again, the court's going to say, well, the officer didn't put a hand on you. He didn't coerce your confession. He used trickery. It's okay for him to do that. You should know better. You should know better, because if the prosecutor was not in the interrogation room saying this is now that's different. A prosecutor can, let me tell you people, a prosecutor can go to the interrogation room with the police.
Okay.
Yes, they can. And if the prosecutor is sitting there with the officer and the prosecutor makes a plea deal with you,
then
that will hold
fine.
up in court.
Okay, then that's fine.
And if the prosecutor offers you a plea deal in exchange for your confession, then the prosecutor is bound by that plea deal in court.
To keep it.
To keep it. But a prosecutor is not bound by a phony plea deal that a police officer makes in that interrogation room, because it's going to be your word against that officer, and there's no witnesses, and the court's going to believe the officer. The officer's going to stand there on that witness, sit on that witness stand and say, that's a lie. I never promised him any leniency, but we know they do.
Right.
So
okay.
the solution to that is you tell the officer, look, I know you cannot make a plea deal with me that's going to hold up in court.
Right.
I need a lawyer present. I want my
Exactly.
lawyer present to hear this plea deal.
Yes.
Again,
Okay.
assert your right to Miranda, assert your right to have a lawyer present.
Okay, great. Now, let me ask you one more thing about as far as them promising things, because I've heard a lot of stories about police promising, well, for one thing, they're withholding food, withholding water, withholding things from you, unless you tell them some of the story, or were you there, or I'll let you call your mother, or I'll let you call your girlfriend if you tell me what happened. See, that's, to me, is saying, like, still saying that if you tell me what happened, then I'll let you do whatever it is that you're asking me to do, if you just tell me some of what happened or what you know. So at that point, when they say that, then say what?
Well, the question you pose comes up a lot in coerced confessions.
Okay.
That gets kind of tricky, because Michigan law uses several factors in determining whether the police extracted a confession using coercive means. And generally, the legal standard for an involuntary confession is whether law enforcement officers use tactics that undermine a suspect's ability to exercise free will.
Okay.
The location of the questioning. The police station is usually considered more intimidating. These are some examples I'm giving you. The length of the interrogation. The longer the interrogation, the stronger the presumption it was coercive.
Okay.
Whether officers gave Miranda warnings, of course. Whether police honored the suspect's request for a lawyer or to remain silent. Whether the defendant was allowed contact with family members or an attorney.
Okay.
Who initiated the conversation? A defendant that freely interacts with police will have a harder time showing coercion. That happens a lot, and I'll give you an example of that shortly.
Okay.
The defendant's age and maturity, the defendant's health or physical state,
Yes.
and his experience with the criminal justice system or lack thereof.
Yes.
So, for instance, you have the Devontae Sanford case, which was on the news, is a perfect example. I was an advocate for that case, and you probably heard he was recently released.
I'm familiar with that case, yes.
The defendant's age and lack of experience in the criminal justice system. Here was a 14-year-old kid who was interrogated over a period of like 18 hours for 2 days. Never had any experience with the criminal justice system. 14-year-old kid with a diminished mental capacity, who was subject to grueling interrogation by these experienced homicide investigators, who finally got him to confess, and it's a question whether he really confessed, who finally broke his free will which is the standard in Michigan, and finally got him to confess to these murders on Runyon Street. And here we are
In Detroit, that's in Detroit, Michigan.
In Detroit, Michigan. Here we are 9 years later, and the prosecutor finally confessed error and set him free, not because she conceded that his confession was involuntary, which we disagree, but Devontae's case is a perfect example of some of those factors that are used in Michigan. The age of the defendant, their experience with the criminal justice system or lack thereof. But here we have police and prosecutors who basically were saying for 8 years, his confession holds water. It was perfect, despite all these factors that showed it was a coerced confession. So again, if the police deprive you of food, of the or won't let you sleep, won't let you make phone calls to your family or lawyers, all of those factors are considered for purposes of determining whether your confession was coerced. And in most cases, I will tell you, it's very hard, even under those circumstances, to get the confession, if you will, thrown out of court. Because what happens, they hold what they call a Walker hearing in these cases, where the courts will, you have to testify in that case. You can't assert your right to remain silent. You have to take the witness stand in court. You have to explain to the judge what happened in that interrogation room. And then the officer comes behind you and he explains to the judge what happens in that interrogation room. So it's a number of criteria the court will use to determine if the confession was involuntary, also known as a coerced confession, and whether the court will throw it out or let it stand.
Great. And I would just like for you to recap as far as Miranda rights, because people really need to not only know your rights, but you need to exercise your rights. What should you be saying?
Be steadfast in your right to an attorney. You have a right to an attorney in that interrogation room, and you assert that right. Leave no room for doubt. You don't tell the officer, you don't ask the officer, should you have a lawyer? You don't you must be unequivocal in your assertion of your right to have that lawyer present in that interrogation room. What you should say is, I have nothing to say to you until I talk to a lawyer. Get me a lawyer. Please, stop questioning me. I don't want to talk to you. I want a lawyer. Be affirmative and assert that right.
Right. Okay. Thank you so very much.
For having me.
This was a great show, wasn't it?
Yes, it was.
Oh my God.
Thank you for having me.
You are so welcome. Thanks for being here. Thanks for watching, everybody.